Live today. We're going to be talking about nannies and how they impact time sharing. And we're going to just give people a few moments to join. So, KB, do you want to talk about some issues that you're dealing with right now, some of your cases?
Oh yes. Just with nannies or anything in particular?
Anything.
Oh my goodness. Okay. One of the issues that I've noticed the most is that right now people are starting to throw the biggest fits when it comes to their houses and trying to get them sold
Mm-hmm.
right in advance
Mm-hmm.
of the summer. You know, the summer is coming up and it is putting pressure on everybody.
Mm-hmm.
And that's one of those things that I'm seeing happen over and over again is now, okay, are we going to get this done? Are we going to get it sold? How's this going to affect the kids?
Mm-hmm.
If there are no kids, it's, well, what about the market? You know, right now, I want to sell it, you know, at the highest I can get it. So right now, it's been a lot of that.
Yeah, the summertime is prime time for people. Okay, the summertime is prime time for people who are going to be relocating and moving because wherever they're going to be, they want their kids to be in that new location by the time school starts. So yeah, that's a big one. What else are you seeing?
Outside of that, I think it's been really, really a lot of fresh beginnings in cases.
Mm-hmm.
I think this year we've had a lot of people switch lawyers, to
Oh.
be honest. It's been a lot of, hey, my last lawyer didn't take care of me at my mediation.
Mm-hmm.
Hey, they told me I couldn't, you know, reopen my case when
Mm-hmm.
there's some huge issue. I hate to say it, but that's something that I've seen a lot. I've seen a lot of that.
Yes.
So it's been a lot of rebuilding, re-educating.
Good point. I will tell
Yeah.
you it's very common that we are the second law firm on a case because I think when people start their cases, they don't understand how complex divorce is. They think it's just paperwork. And I think over time, once they go to court and they get a bad outcome, they go to
Hmm.
mediation, they feel unprepared. They go back to some of these consultations they've had, or they go back and look for attorneys that are family law specific attorneys, and I think they start to understand why it's important to have an attorney who their practice area, a portion at least of their practice needs to be dedicated to your specific type case type. So yeah, that is
Yeah.
something that has I've noticed that a trend I've noticed a while back ago. We are usually the second attorney because the second firm because I think people just they don't understand how complex family law is.
Yeah, exactly. And I think that sometimes it comes from a place of people, and it's natural. You know, they don't
Mm-hmm.
want to spend the money that
Mm-hmm.
they think, oh, this is the best person I've seen, or oh, I really enjoyed that consult, but it seems like it'll be so expensive.
Yeah.
And the truth is that it's more expensive to switch attorneys and have to start over or repair issues than to start off and make the investment now for what you want the rest of your life to look like.
Absolutely, it is. It's an
Hmm.
investment that you make into your case. That's a good point. That's a really good point. Anything
Oh,
else interesting that you've noticed in your consults or with your cases before we get started on our topic? We'll give people a few more minutes to get logged in.
well, as far as the consults, I would say that there's been a influx recently of people who are now, well, again, again it's a branch from what we were just saying, which
Hmm.
is just that it's people who are seeing that things are different. Um, Unfortunately, I think it's a lot of, you know, really a lot of abuse. There's
Like
been a
domestic
lot of
violence.
abuse with the partners and also with the children.
Okay.
There's a lot more of that going on, and it really makes me feel really concerned.
Hmm.
Um, but there's been a lot of things, and people don't know how to bring that in front of a judge. You know, not everybody. It's not as easy as just, hey, I know what's happening. You know, my child has told me what's happening.
Yeah.
There's so many technical steps that go on. You may be thinking about the consult that I had recently
Hmm.
with a person who had several kids who were really the victim of abuse and neglect,
Hmm.
and you know that person was very concerned because they weren't able to achieve their goals because they
Hmm.
thought they could do it on their own and just tell the judge this is what's happening, and it did not go well for them, and I
Yeah.
feel very badly for that person and their children.
Yeah, that is.
Yeah.
Okay, we're going to go ahead and get started on our topic just to kind of give you a little guideline. This is going to end at approximately 1 p.m. So we're going to start talking about nannies, how it impacts time sharing. As we get questions, we will answer the questions. If for any reason we don't get to your question, please feel free to DM us and we will still try to connect with you and answer your question. Also, keep in mind this is not intended to be legal advice. While we enjoy engaging and doing the TikTok and Instagram lives, if you have a legitimate legal question that you need an answer to or you need legal assistance, it is important that you know that you do need to seek the services of an attorney. Lastly, as you watch today, it is free to like and follow. So please like, follow, and engage with us. Yes. Okay, let's get started. Nannies, time sharing, and how it impacts overall custody or time sharing in the state of Florida. I will tell you, there was a time back in the day when you said you had a nanny, so this third party person caring for your child, that I would notice the other party, the party that did not use the nanny, would feel like, okay, well, if the nanny can watch the child during that time, I'm better suited to watch the child. And it is in the statute that the court does evaluate how much time children spend with third parties. I do believe that we have evolved now that people do not look at au pairs, nannies, the way they used to back in the day. I think we are looking at them kind of similar to childcare, and it does not always carry that negative impact or connotation that it once did.
And I think that's one of the trends that's changed so much lately. There are now people who you would say are, they're making decent money, they work, maybe they have a career, maybe they're at the beginning of their career, but they still employ the services of a nanny regularly, sometimes in combination with other forms of child care. You have, grandmothers or parents or cousins, and then you have a nanny for some of these days, and then you have child care on the weekend, or even the gym. So it is a lot more common, and it's really at most income levels at this point.
Yes, I think that has something to do with the rising cost of childcare as well. I think when people evaluate whether or not they're going to employ a third party to assist them, they look at, well, daycare is, depending on the age of the child, right, 165 to 275 or 300 a week. I can maybe pay someone $500 a week and they can take the child to soccer lessons. They can help me to a doctor's appointment, or they can cook and clean in the home, and that'll make our life a little easier. So I do think the cost of childcare probably contributes more to why we see people looking for in-home help. And keep in mind, nanny, in our experience, isn't always a commercial service. It's a relative that's not working or that may be retired who's performing services and care for your children that you would normally perform if you were available to. So don't think of it in the commercial context only. It also is just when we have these third parties who take on a responsibility beyond what a daycare would do.
And I think that reminds me of a case that we've had where we had a client where we had to very clearly explain that the other parent using a nanny, that nanny didn't have a degree, they didn't have any credentials, CPR, nothing. They had a degree from a university somewhere that I've never heard of, backyard university or something. And they still matter. This person was still putting money into that expense, and we had to deal with that. It wasn't enough to just say, well, this is not a real nanny. They're as real as the money you put into them.
Absolutely. I think the bigger discussion that comes from it is who pays for the person.
Absolutely.
Yeah, I think that's a big piece, because you may have this one parent who needs the services of this nanny to be able to work. And I don't care how much money someone makes, they always want some sort of contribution from this other person, especially if we're looking at, okay, if I had childcare, it would be $400 a week. What's the difference if I'm paying someone $600 a week and you help pay for it? So one thing that impacts time sharing is when we calculate child support, how do we calculate this nanny expense? Do you want to talk a little bit about that?
Yes, I do. When it comes to the nanny expense, that is something that goes into usually the child care column. So in Florida law, they're going to look at things like how much time your kids are spending with both parents, what do you both make, and what does it cost to care for the children when you're both not around. And that child care expense, in my experience, is one of those big ticket items that can take you from owing a few $100s a month to suddenly you owe $1,300 coming out of your check every single week by the end of the month.
It's heavily disputed because the person that's not using the nanny, they don't want the child care, they don't want that expense included. But I think from a practice standpoint, we look at, well, how much is it? Is it feasible? Is it comparable? You worked on the case, you're working on a case right now where the judge basically said, hey, I'm going to cap it at this number though, because childcare costs X. And the statute does speak to costs and how much people can
Well, it's a
charge.
reasonable, right, and it has to be reasonable.
Hmm.
But again, proving that in front of a judge is not as easy as talking about it.
Yeah.
Especially when you're dealing with situations where, and I'd like to ask you this: what is your thoughts on when one parent wants to use the nanny, but the other parent says, "I've got all the time in the world. I work remote.
Yeah.
I could be spending that time with our maybe young children or homeschool
Hmm.
children alone."
I think that is one of those situations where people have to embrace the fact that once you decide that you're not going to be in a relationship anymore, or you're no longer in an intact marriage, that other person still deserves to have time with the children however they can. And if they have to bring in a nanny, an au pair, the neighbor who, the kids have known all their life to help facilitate time sharing, I will tell you in my experience, I don't see a judge knock the person for that.
Yes.
I don't see a judge say, especially when we get to these professions like physicians. A lot of physicians have nannies and au pairs. Or when we get to professions where people just have a work schedule that is so rigorous that they need some help. So they're not going to penalize you for having someone get the kids from school, take the kids to soccer, and do things with the children that you can't do for a finite period of time.
What do you think about, and I feel that I've seen this a lot where people, they're most frustrated with, oh, I wasn't a part of that decision. Do you think that plays into how fast you need to, begin your litigation or bring this in front of a judge?
Yeah, you need to document that. That is actually a really good question. A lot of people they say, okay, well, why didn't you tell me though? Like, why wasn't I included in this discussion to select this person if they were going to be
Exactly.
taking them to the doctor and spending time with them? It's definitely a very heavily litigated issue. Did we have any questions?
Yeah, so we have a couple of questions here. If we have a nanny, how does that affect a first right of refusal? For instance, dad has a nanny and I do not, but there's a first right of refusal clause in the parenting plan. How does that work?
I think I can take that one.
Please.
When it comes to the first right of refusal, the nanny is going to be a big, big impact on that.
Mm-hmm.
Usually, the first right of refusal is about which parent is going to watch the child when we're unavailable. So, what we have to decide first is, does the nanny count as that parent being available in the first place?
Mm-hmm.
Is the nanny just as good as mom or dad?
Mm-hmm.
And if not, or even if they are, is it always better? Do we prioritize mom and dad time over nanny time? So what you want to make sure you are clear on and what's communicated clearly in your parenting plan is that are we trusting the nanny to pick up the slack mutually when there's when we need to do any child care or when someone's not available, or are we going to place the parents being involved over everything else?
We actually have a question too on Facebook. What about 300 miles with a 16-month-old with a 50-50 ruling? So I guess this person is wondering, like, would a nanny be acceptable with such a young child? In my opinion, I think that's really young. I think we're going to have to go back to what was going on when the relationship was intact. For example, was there a situation where the parties had discussed, do they have other children? Did they discuss having to use a nanny? Was the nanny there from the very beginning, or did this person just bring the nanny up when they separated? The person says no prior bonding and refused to complete with temporary order for 4 supervised visits. Yeah, this is kind of detailed. I would encourage you to contact the office and speak with Gabby about scheduling a consultation so we can really go into detail with you about your question.
Next question: are Florida laws on child support changing this year in regards to how it will be calculated?
To my knowledge, right now, no. At this point, there hasn't been any changes that are on the horizon.
Yeah, I agree.
Yeah.
I'm sorry. These questions are coming up on Facebook, and I'm trying to like listen and look at them.
Why do courts cater to only mother rights?
Oh gosh.
I'll take this one as the resident fellow of the firm. So, the courts do not cater to mothers' rights. In my experience, more recently, especially, I'll say this. In the last 5 or so years, there's been a push to make sure that the parents' rights are equalized. What tends to happen is that mothers may, in a traditional, whatever that means to you, traditional marriage or relationship, they may be doing a lot more of the lion's share. And that usually works when we're in an intact relationship together. But when we're separating, what a lot of men, fathers, husbands have to overcome now is that, okay, now I'm going to have to take on a little bit more of that share. But just because you may not have done it before doesn't mean that you're not worthy of 50-50 time. Doesn't mean you're not worthy to be a part of your child's decisions. It's extremely important, and you should have those rights protected at all times. And that's something that I do feel passionate about, is protecting, whether it's men or women, protecting those rights.
Absolutely.
It's about who is the best caretaker, or
what's in the best interest of the children.
Yeah.
How much involvement can a third party be a part before becoming an interference?
Yeah.
Ooh.
Okay, so I will say this. You want to always first go back and look at how involved that third party was when you all were intact. Whether you were on good terms before there was a court case, whether it was when you were in a marriage. The problem that a lot of clients have, or people have when they're going through the divorce case, is fire time or custody, right? There's something has happened. We're no longer going to be together, and we need the court to come in and help us establish rules. The problem that people have is they want to sometimes ignore everything that happened before that time. And as lawyers, when I prepare a case for trial, I have to know the history of what has happened since that child was born, not what happened on the day that you broke up or the day that someone filed for divorce. So I think it's really the correct answer for me would be, it's the case-by-case basis. What were the parties doing when they were together? Was it something they agreed to or discussed? Ultimately, in the state of Florida, mom and dad have rights. So it shouldn't be to the point that this third party is making healthcare decisions. Your child gets to be vegan with the third party. But if it is a dynamic where you all have both relied on this third party throughout the relationship, or there was an understanding that this third party would be involved, it's going to be very difficult, in my experience, to exclude them in once you're in a court proceeding and in litigation.
How much is the consultation?
We have 2 consultation options. 30 minutes is $200 and 1 hour is $400. I will tell you, it is, I'm biased. It's probably one of the best consultations that money can buy, though. You're doing our consultations here with licensed attorneys. We have a very skilled team from intake to paralegals, but you're going to either meet with attorney Bryant or myself. We take our time, we hear what's going on, and we gauge whether or not, one, it's a fit for you and for us, but also, can we help you? So it's definitely a strategy meeting that you have with the attorneys. It's not just one of those passive things where we say, okay, and here's the price.
Why is it so difficult to have an out-of-state child support order enforced or followed in Florida?
Well, when you have an out-of-state child support order, first off, that's a really great question. The difficult part for that is that when we're dealing with different courts, there are different rules, completely different standards, completely different government agencies getting involved, and they all operate almost like you're in completely different countries, not even the same state.
Yeah.
One of the things that is most difficult for people is understanding that, the system, the law, the courts, the state agencies that get involved in these cases, they do not work in tandem almost at all.
No.
So then when you add another state to the mix, that might be required in order to enforce your child support order. But it's going to be an uphill battle to make sure that you can hold the payer accountable for the support that they owe, not just you, but for your child's support.
Another question. I feel like it's unfair that my ex wants 50-50 custody but isn't the one actually parenting. Is this common?
First of all, I think that's unfair too, honestly. I think that's unfair too. But the question is, who's parenting then? Is it a relative? And then what do we call parenting? Is it that there's a small gap that when the child gets home from school, there's a third party like a girlfriend or new wife helping? Or is it a situation where that person is doing everything? And you have to keep in mind that types of facts are difficult to prove because we don't bring young children into court. And when you take dad to court and dad, I'm just gender role assuming here too. When you take dad to court and dad testifies, dad's going to say he cooks, he cleans, he's doing the homework. And you're going to say, no, that's not true. But then what is your no based on? Probably what the child is telling you. And you're good common sense. You know that person. So it's not fair, but it is one of those situations that it is difficult to prove. Usually we prove this by, if the child is young, we're looking at the sign in and sign out sheets at the daycare, who's dropping off, who's picking up. If the child is going to the doctor, I'm not going to look at one medical record where the child broke their leg at school. Let's get the body of medical records and see who is taking the child to the doctor. And I just want to add, you need to be very mindful who takes your kid to the doctor, because those medical records, they are chock full of information, not just about the child, but they also will mention who brought the child there, whether or not that person was alert and paying attention and attentive. But it's one of those situations, it is really hard to prove that they're not taking care of the child absent clear abuse or neglect.
If an attorney reps a wife, then becomes the judge later in the matter, is it constitutionally disqualified?
I'll let you take it.
Yes. If the judge can't sit on a case that they worked on in any way,
you have to recuse yourself. They're supposed to automatically do it. These are some good questions today.
I'm having fun.
They're good.
How does the court determine who is the primary parent?
So Florida has gotten away from primary parent, secondary parent. You may be talking about a situation where this person has the right to make ultimate decision making, or if you have sole custody. They don't use primary anymore in the state of Florida, but let's just assume it's majority time sharing. They look at the statutory factors, what's in the best interest of the child, and the person who has equal or the majority of time sharing is going to rest on what is in the child's best interest.
Should I document my daily involvement even if I have a nanny?
I would.
Absolutely.
I would. I would also document what the nanny does to what services they're providing for the child.
Can the nanny be subpoenaed or asked to testify?
Yes.
I looked away because yes, we have brought them in before. Depending on what side of the table we were on, absolutely. They are not legal parties, but anyone who's interacting with the child, taking care of the child, school teachers get brought in, which I have found that judges hate, right? They feel like the teacher should be at school teaching, but school teachers, I've subpoenaed the head of a daycare before to talk about an encounter that happened at the daycare. Yes, anyone that is interacting, who has evidence, who's witnessed things, they can be brought into these cases.
At what point does childcare become delegating parenting?
I think the line is when the nanny or the child care is deciding the path of your children long term. There's a big difference between I am dropping you off at the routine destinations, or even if your nanny is helping you with school or learning. There's a big difference between that and, okay, I think that this trip will be best for you. I think that they want to do this, and now the nanny is making all the propositions for what's going to be fun for your children.
Yeah.
And honestly, it can be, you have to be very careful. You know, children only have two parents. You need to make sure that you're one of them.
Who is scheduling hearings, the judge or the attorneys?
The judge's assistant.
Hi, Angela. Yeah, it's the JA, but the attorneys have to basically request for the judicial assistant to schedule the hearing. I think you guys go online and use like I was gonna say a portal. I don't know. I go to court. And
Does the court ever schedule hearings?
Like on their own?
On their own?
Yeah, if it's an emergency situation, let's say someone files an emergency motion, and yeah, the court can set and will set a hearing if there's a motion, but just randomly. I think a lot of, especially pro se people, don't understand this. In my experience, they don't just look at the docket and start saying, hey, this needs to happen. No, you have to move your case along. I do think they have a process for people who are pro se and they're doing like uncontested divorces. But for the most part, no, you have to request these meetings with the court.
It's a lot of communication.
Yep.
What areas of Florida do you service?
We serve all areas of the state of Florida. Whether you're in the Panhandle, down south, Central Florida, we're everywhere.
Yeah.
What expectations does a custodial parent have to meet?
So once again, Florida does not do a primary parent or custodial parent. So the expectation is going to be for both parents, and the statute outlines what is in the child's best interest. So I could give you a few of those factors, or if you want to give them a few of the factors.
Well, yeah, I think some of the factors will be your ability to facilitate the relationship with the other parent. That's one of the big ones that sometimes seem counterintuitive.
Yep.
Just looking at who's doing what every day. What is the history? Are you exposing the children to any violence, any drugs, anything like that? Is it geographically viable? Meaning, are we able to actually follow through on these duties based on where we live and where the schools are? It's a very, very long and thorough list.
20 factors.
Yes.
That the court does evaluate.
Does the court care about the parenting responsibilities from 2 years ago or the present year?
I think both.
I think that when it comes to the beginning of a case especially, that's when the court is going to care the most about everything that's ever happened. But if you're coming back to court, they're only going to care about what happened since you were last there.
I think also they look at the totality of what's going on too. Sometimes people are mentioning things that are too far removed. So someone driving with the kid, and they didn't put them in a car seat, and it was 6 years ago. That's not gonna ring heavy, right? The kid is probably 10 years old and walking now.
Yeah, but there is a difference between that and, hey, mom or dad has just been out doing whatever they want to do for 4 years, and now they're coming back and they want to have 50-50 time sharing.
Yeah, that's true. Okay, we have another question. How much do judges try to balance fairness when unilaterally decisions was done? So ultimately, when someone makes a unilateral decision, like I'm going to take the child to a doctor's office that I didn't talk to this other parent about, the court is first going to evaluate the totality of the circumstances. So let's say we had a parent that was in the midst of a domestic violence situation and they had to get up for their safety and the safety of the child and flee. That is going to be looked at very differently than a parent who just uses their own autonomy and is not thinking for the child, but maybe their own personal. So let's say mom and dad gets into a fight. Dad decides, I'm going to get our kids and change schools and move. Judges don't like that because they expect parents to always put their kids first, and even in the midst of turmoil, even in the midst of danger, you're going to put your kids first. It's like running out of a house and not getting your child and leaving them there. It's the same thing when you are making a unilateral decision. Were you thinking about the child? So I believe judges tend to be very fair, and I think they look at what was the totality of what was going on.
If I'm in a relationship where the other party is not fully present, when should I start collecting evidence for a case, even if I'm not sure I'm going to file yet?
The moment they're not present. Everything. Pictures. I always tell our clients, hey, if you're doing something fun with your kids, take a picture. You want to show who was there for the birthday, Christmas. When you register the kids for school, that first day of school picture. Text messages. Text is really big. You want to communicate in a professional, business-like manner. Hey, reaching out to you, our child, that is very important. Oh, our child needs X. Our child is going to be going to school. And you want to have that text communication as well. But it starts from the very, very beginning. And that is because once you get to a court posture or speaking to an attorney, people don't know what legally is going to hit what we need, right? What hits the statute or what the judges are going to need. So I would start collecting it all.
Alrighty, and one last thing, we have a fellow attorney from South America, so they just wanted to say that you guys are doing a great job on your live, and they're joining in all the way from South Africa. Sorry.
Oh, amazing! Thank you. That's what I love about the internet, being able to connect with so many people. So thank you so much for tuning in today. That is our time. I hope we've answered your questions. We really enjoy doing these lives. If you have any questions, please contact us directly at 407-420-2311. You can also follow us on social media at Divorce Lawyer Orlando. We drop content every single day about a myriad of family law issues. And you can also reach us at www.myphlaw.com. Myself or anyone, or Attorney Bryant, or our lovely paralegal team, or Intake would be really glad to help you. Thank you so much. Have a great rest of your day.
Thank you.